we should start with Professor Hwang.
Thank you, Yundu. Before I begin my presentation, I would like to thank the Taiwanese Law Student Association for organizing this presentation. It's indeed my pleasure and honor to be here after last weekend's SJD Forum meeting, and it will be my great, indeed my great honor to be able to sit here and to present this topic together with Professor Tushnet. I still remember before I came to Harvard for my LLM in 1990. In that summer, I went to Georgetown for an orientation program there, and Professor Tushnet gave a 3-hour lecture on constitutional law, to our class. And then I have to say, Professor Tushnet is the only lecturer in that entire program whose name I still remember right now. And a couple of years ago, when Professor Tushnet had a chance to visit Taipei to give a lecture there, and I was one among many an audience. And five years ago, I once visited Harvard Law School again as a visiting scholar for one semester, and also I audited Professor Tushnet's comparative constitutional law. Also, Well, so that's my personal memory, my personal encounter of the with Professor Tushnet. And then the topic I'm going to present is transitional justice and constitutional changes in Taiwan, and I'll try to finish my presentation within 25 minutes. And the whole structure of my presentation will be divided into 4 main sections. First of all, I will give a brief description of the major so-called injustices before Taiwan's democratization, and then I move on to also to give a brief analysis of the constitutional changes in Taiwan since 1987, and then I'll describe what has been done in Taiwan regarding transitional justice on 3 aspects: fact-finding, and on the responsibility of wrongdoers, and also on the compensation of victims. And finally, I'll reflect on Taiwan's case and by analyzing what has been missing and try to explain why. Okay. And to sum up, I would describe Taiwan's case as one of transition without justice, or without much justice, as I will demonstrate later. Here's the map of Taiwan and its location. So you may get some idea where it is, and don't mix Taiwan with Thailand. Even though these two names sound kind of similar to each other. Okay, that's the first part of my presentation. The so-called major injustice. Usually we use the year of 1949 as the dividing years, and before that there's a 228 incident which occurred on the February 28th of 1947. So that's why we calling it 228 incident. And after that, after the 49, when the KMT, the Nationalist Party, was defeated, the Chiang Kai-shek Party was defeated in China, losing the civil war to the PRC, the Communist Party, and moved to Taiwan. And since then, roughly beginning from the early 1950s all the way down to the mid-80s, this period we usually call the White Terror period. And before 49, in terms of the 228 incident, I have a quick comparison of these 2 events. The targets first is the difference between the target. The 228 was because the 228 incident happened in 47, and at that time, Taiwan was just taken over by the Chinese government from the defeated Japanese government at the end of the following the end of the Second World War. So, well, it's mostly the 228 incident. The most victim of this 228 were so-called native Taiwanese, particularly the elite. Yeah, and by comparison, after 1950, during the roughly almost 4 decades, the so-called White Terror, among the victims, they include both native Taiwanese and also the so-called Chinese mainlander or mainlander Chinese. In fact, there's a statistic showing that among the victims during the White Terror period, the so-called mainlander account for almost 40% of the victims during that time. So it is, in terms of the target, is even a more widespread suppression of the local people in Taiwan during these 4 decades. It is not only a suppression against the so-called native Taiwanese, it's a suppression of whoever is considered so-called against the government at the time. And then in terms of the means, there's a major difference. During the 228 incidents, basically it's a kind of use of force or military force by the state without any color of the law. By that I mean, well, the people would get arrested without any warrant, and then they would be executed without any trial at all, either in public or secretly. And they also sort of, particularly in the very beginning, there are also the random shooting in the street, things like that. But during the White Terror period, usually the suppression usually has the color of law. A lot of them were carried out, well, formally, in a very formalistic sense, by court-martial or by military or judicial trials, and then sentenced to death or long-term in prison or things like that. Okay, and the actual number of the victims during these 2 instances are still, well, unknown. There's only an estimate number of it. And here I give you some idea. Because later I'll explain, now we have 2 different statutes which give compensation to the victim during this period. And then based on the number who did apply to the for compensation, for example, in the 228 instances so far, there are already almost like 10,000. 10,000 persons who did apply for compensation, but the number has been considered far below the actual number. But still, the so-called 10,000 to 20,000 people who got killed is only a very well, not so accurate estimate. Yeah, I just want to give you some rough information of what was going on at the time. And then during the White Terror period, the number of victims was a lot more than that in the 228 incident, but still the numbers are very varied. According to the Ministry of Defense, the MOD, they published the list number so far, and then according to the Ministry of Justice, there should be around like 30,000 political trial, and then the total amount of the victims is estimated to exceed or to be somewhere among like 140,000. But according to the Judicial Yuan, which is the highest judicial institution in Taiwan, in charge of the O-level and instance of the courts, in Taiwan. And according to the Judicial Yuan, the number of cases are, well, a lot more, probably 2 or 3 times of that as provided by the Ministry of Justice. So still, we don't have the actual number, but what we can be sure is given the length, the total length of the period, the estimated number of the victims during the White Terror period should be a lot more than that number during 40 to 28 incident. Okay, and then I move on to my second part. What in terms of the constitutional change in Taiwan, and also the transitional justice measure since then. I used the year of 1986 or 1987 as the dividing year or the beginning era for the Taiwan democracy, because in 1986, the first opposition party, the DPP, was founded, and then the next year, 87, in July, Taiwan ended his martial law rule, which lasted for 38 years, and then also, and then in 91, Taiwan formally terminated the state of so-called emergency, and then we had a new constitutional amendment since then. And during the same period, on the part of transitional justice or justice, right before the KMT, the ruling party of Taiwan at that time, lifted the martial law rule. Right before that, and our parliament passed a law called National Security Act, to so-called arrange the legal order after the end of the martial law rule. And one among many provisions in this National Security Act was to foreclose all possible appeals from the court-martial decision made during the White Terror period or even before that. And then that law was later declared constitutional by our constitutional court in the year of the 1991. Okay, and then from 92 to 96, Taiwan, we have the first election of our parliament, and again our first direct presidential election in 96. And at the same time, I would say most of the major regarding transitional justice were created and taken during this period. I mean, during the probably from 91 to 96 or 97, around this period, including the major measures, including in the year of 92, our government released the first official government report on the 228 incident. And then in 95, our parliament passed the first and the second compensation act for the victim during these two periods. And also the government began to build or rename the national park or memorial park, or to build monuments or things like that. Okay. And then in the year 2000, the opposition party DPP won the presidential election for the first time. So that was the first party turnover in the history of Taiwan. And during the 8 years of DPP rules, from 2000 to 2008, the DPP did, well, in fact, not very much regarding the transitional justice. And as compared to his predecessor, the KMT government, and what has been done, what the DPP has been done, were mainly in the year of 2004, the government began to issue certificate for restoration or reputation for the victim or the victim's family, but a referendum on KMT party assets failed in the year of 2008. And then also in the same year, the KMT won the presidential election again. So that's the second party turnover. So, and now, in this year, in January, the KMT candidate won again. So now it's still a KMT rule. And what KMT, after KMT came back to power, what it did regarding the transitional justice, among many good things, and there has been some sort of bad things. One of them, as I listed here, is the after 2008, the county government reclassified some or many secret files during that period. Yeah, so that's the probably a kind of setback. Okay, so and in the following, I'll sum up what has been done. Yeah, basically in terms of the fact finding, well, we did have the government survey report, but it's far from complete. And then we did, particularly before the 2008, our government began to declassify certain file and release it to the public. But on the other hand, so far we haven't had any retrial of the political trial done during that period. And on the victim, basically, that's the most so-called obvious part that our government has been doing, mainly including official apologies and monetary compensation for the victim, and then also restoration of reputation. And then only beginning from a couple of years ago, they began to return some sort of the private document, like letters or diary, to the victim or their family. But on the other hand, in terms of transitional justice, our court has been denying any formal appeals from either the judicial court or the martial court during that time. And also there hasn't been any formal like a damage or charge or responsibility against any living individual wrongdoers. Yeah. Okay, and then come to the third section on particularly on the wrongdoers. As one political scientist in Taiwan pointed out, the Taiwan case is kind of we have 10,000 victims without a single wrongdoer at all so far. Yeah, there hasn't anyone has been formally charged or formally held accountable for whatever event happening in that period. And even for those living so-called wrongdoer, they are protected under the statute of limitation. They even got promoted to even higher ranking of the government offices, and then they enjoy the same free speech right to talk back and even to sue whoever who dare to point their finger to them and say you were the wrongdoer at the time. And then, well, there was a case that the grandson of the Chiang Kai-shek once filed a lawsuit against several researchers, and as well as against the then our former president, because our former president cited a report done by a researcher saying that the Chiang Kai-shek should be held accountable for the 228 and the White Terror, and so the grandson of the Chiang Kai-shek just filed a lawsuit against everyone, saying that. But well, fortunately, that the case was dismissed by the court later. And then so that's the basically the whole picture of what has been done in Taiwan. And in terms of the monetary compensation for the victim, is probably the most obvious and most so-called, well, not maybe I should not call it effective. The most obvious measure taken by our government, and I give you some number of the amount of the compensation. Yeah, and compared to, for example, the Argentina, which gave each loss of human life during its time, the amount was like US $220,000, and well, that's roughly the same amount of money we give to our victims for loss of their life during the period in Taiwan. And then also the U.S. the Congress, as far as I know, once apologized and granted personal compensation of US $20,000 to each surviving prisoner of Korematsu, yeah, during the Second World War. Okay, and then here is this is not a joke. I am not joking. LM program. Yeah. First, I sum up in 3 sentences. What what we did is still we provide legal protection for the wrongdoers. And then we had very limited fact finding, yeah. And then also we paid a lot more services to the victims. And the M stands for the monetary compensation and a sort of moral indication by establishing and building quite a lot of monuments so far. So that's the conclusion made by a political scientist, Professor Wu. He said in one of his very famous papers in Taiwan regarding our transitional justice, says in Taiwan we have 10,000 victims, but without a single perpetrator so far. Okay, what missing? Well, basically I won't repeat much of this. And then it's compared to other models, other countries facing a similar problem of the transitional justice. Taiwan probably belongs to the weakest model, very similar to the Spain. Usually they call it kind of disremembering. Yeah, but in some scenarios, I would say Taiwan probably has done could have been done much better than this, as I will explain later. Okay, and why? Why? I guess it has to do with a couple of reasons. And first of all, I guess it's related to the nature of democratic transition in Taiwan. Because in Taiwan case, here I use the terminologies employed by Professor Huntington. Yeah, and well, if you look at the work done by Huang Ling's Yale University, well, usually the political scientists here use very similar terms to describe different type of democratic transition. And Taiwan belongs to the type of so-called transformation, which means it's still a top-down, controlled by the formal regime, the whole democratic transition. And what is more important is the formal regime continuing to be in power even after the democratization. Yeah. So as compared to the replacement or the model replacement of the replacement, yeah, well, that would explain why so far we haven't held accountable of any wrongdoer during that time, because, and also related to the second factor, the KMT continued to rule for certain years after Taiwan began its democratization, yeah, until 2000. And then, so far, even though the DPP once won the presidential election 2 times, the first in 2000 and the second in 2004, but in terms of our parliament, we still have no party turnover at all. Our parliament has been firmly controlled by the KMT, yeah, before and after democratization, and even until now. So, if you want to pass whatever legislation against the wrongdoer, it was blocked there in the parliament. And also, another factor might be related to the economic development of Taiwan during the same period of the so-called White Terror period. Yeah, during the 3 or 4 decades, Taiwan economy, yeah, grew at a very rapid speed, and which has been considered a positive legacy of the so-called authoritarian rule. So it's kind of mixed feeling, a mixed response to the previous authoritarian rule among many Taiwanese peoples. And also we have our own ethnic tensions between native Taiwanese and the so-called mainlander. And then, okay, and then, so there's a public mentality, a very mixed the opinion among the citizens on this issue. And then many of our citizens will consider the issue of transitional justice is merely another issue for power struggling between the DPP and the KMT. It's kind of power issue, it's not justice issue. Yeah, because the DPP wants to use this issue to fight against the KMT. So it's nothing about justice, it's all about politics. So these are the couple of reasons I try to, well, maybe we can, to understand why has been done and has not been done in Taiwan regarding the transitional justice. And then the final part of my presentation is, okay, what can we go from here? In fact, here, well, we had 2 conflicting goals. Well, I use the peace or the justice. You want peace, short-term peace or long-term peace. And then if you want more short-term peace, maybe, well, you don't want too much transitional justice in that regard. Okay, and then also, if you look at other countries, there are, well, different models. Basically, there are three major models. The first one is practiced in Spain. Usually they call it this remembering, just forget the past, just looking forward. Okay, and the third, the most the strongest or someone more extreme model is called lustration. Yeah, that's not only find out the truth, but we have to also hold accountable those wrongdoers. For example, in the East Germany or many Latin American, they place criminal charges against their former head of states, their former head of government, or even extend the criminal charge to the high-ranking government officials at that time. And in between, we had a model of South Africa. Yeah, they established a so-called Truth Commission to find out the truth and then forgive. So they don't place criminal charge against those wrongdoers, but they insisted on finding out the historical truth. So these are different models. We may think from here and for our next step in Taiwan, but common in all of these three models has been the compensation for the victims. And well, actually, we have already done it in Taiwan. Okay, and here is some preliminary thought on what should be done in the future in Taiwan. Probably we should have a like a truth commission modeled after the South Africa to further find out as much as possible the truth during the period, and basically on wrongdoers. My idea is we should still have some sort of the formal declaration of wrongdoing during that time. So I will code it to find them guilty, but without penalty. We don't need to charge them or to put them in the jail. Well, and then because probably they will begin, well, for the most part, it will become a kind of witch hunt in Taiwan, yeah, in the future. So, but I still find it's important for either the court or the political institution in Taiwan to say what was wrong and what was right during the time, yeah. And then for some, not all, unsolved political murders, particularly which occurs in the 1980s, we might still persist in not only initiative by placing the criminal charges against those possible wrongdoers, yeah, for this limited number of unsolved political murders. And then as far as other measures, for example, someone suggests the use of international human rights law, particularly the crime against humanity, or the liquidation, some or part of the calamity party assets, or even some sort of hate speech regulation in Taiwan. Personally, I do have some doubt about this measure. I'm now a very, very big fan of the hate speech regulation, even though, well, that kind of, for example, Holocaust denial speech was punished in Germany and in many European countries. And then, but in Taiwan, I don't think that kind of legislation could work out and could be effectively enforced. Okay, and then before I conclude my presentation, I would like to just tell all of you a story, a true story. In the year of 1968, there was once a very, very famous writer at that time. He translated a comic strip of the U.S., the Popeye the Sailor. You know all that? Popeye the Sailor, boom, boom, boom. Yeah, okay. It's a comic strip. And then that strip was about the Popeye and his son. So they end up on two small islands. And the Popeye said to his son, "Son, I am the king of this island, and you will be the king of that island in the future." And then, okay, and so things like that. And then Popeye delivered a speech to the island layer. And then the writer translated the term "my fellows" into Mandarin Chinese. It means like my fellow countrymen. Yeah, and that phrase in Mandarin happened to be the same phrase used by the Chiang Kai-shek during his public speech to the whole nation. And for that reason, that speech was arrested, and then finally he got sentenced for 12 years. It was a very ridiculous case. And then what's more, after the writer was released from the prison, a couple of years later, he met a guy from Taiwan's FBI, and that guy happened to the agent who tortured him. And they have some sort of conversation. And during the conversation, the writer pointed to something related to the traditional justice, things like that. And the agent stood up and held the hand of our writer, looked into his eyes, very, very serious, and said, "Mr. Kuo, you know, we FBI people never torture people. Never torture people. We never did that. You know that." Well, I found this is true story, because the writer later just wrote this story into his memoir and published it on the newspaper. And that guy was once threatened to sue him, yeah, but he never did. Well, the reason why I'm telling you this story is I always find story like this very, very troubling. Yeah, that's why, because, well, if you can give the compensation to the victim, but how about the so-called those wrongdoer? And you can look at those wrongdoer. That guy was later promoted to become the deputy director of our FBI, and then got even promoted to our Ministry of Justice, in charge of the matter, in charge of the section which supervises the so-called the government ethics, or government ethics. And people like him can retire with ease, with a decent pension, with without any liability. Yeah. So that's well. Okay. I won't say anything anymore, and I will conclude here. And then thanks for your listening, and I look forward to your questions and comments later.
Just a break. Please help yourself with the food if you have. Mr. Tushnet.
Thank you. I'm happy to be able to talk with you today. I am not an expert in transitional justice, nor about Taiwan, but I have thought about issues of transitional justice in connection with constitutional law and constitutional reform. And so I'm going to offer some reflections on the sort of worldwide experience and lessons, if any, from what's happened around the world. I want to stress, and this is something I will say in another way in a moment, that the Taiwanese case, as described by Professor Hwang, is different from many of the practices or cases of transitional justice elsewhere in the world, because, as he put it, the transition is incomplete in Taiwan. And it's particularly important to emphasize the continuing political role, recognized, acknowledged, and in some sense legitimate political role of in the parliament of the KMT, which both complicates the issues of transitional justice, but also makes the case somewhat different from the experiences of transitional justice elsewhere, such as the lustration examples or the South African example that Professor Hwang offered at the end. I want to begin by suggesting that there are two contexts in which issues of transitional justice arise, and they are, as I've tried to describe them, associated with a description of a transition from what to what. And the two categories I have are situations which are described in the literature as conflict situations, meaning situations in which there is serious, extended, essentially military, violent conflict on two sides of the issue of two sides in the country, ethnic division, political division, but serious and in this setting, importantly, military, with some degree of military character to it on both sides. That's one kind. That's one of the sort of starting points. The other starting point is more like the Taiwanese, a situation in which there is a dictatorship or an authoritarian government that, for a variety of reasons, is displaced, or in the Taiwanese example, is partially displaced by a democratic or more democratic regime. These are the Eastern European examples, and to some extent Taiwan, where the authoritarian or dictatorial regime in some ways collapses from within, without there being extended, essentially military conflict on both sides. Now, these are situations, of course, in which the authoritarian regime has been exercising essentially military force against its opponents when it was vigorous, when it was fully established. But typically what happens is, as the transition approaches, the people in power understand that they're not going to be in power much longer, and that it's not wise for them to continue to use the same kinds of military measures that they had been using for decades earlier. Okay, so that's the from what part of it. The to what part of it is that in the core examples of transitional justice, the conflicts are resolved, which is again different from the Taiwanese situation. And now when I say the conflicts are resolved, I mean to refer to both the conflict society situations where there's armed force and the authoritarian situation. But for me, an interesting characteristic of these post-conflict situations, post-resolution situations, are associated with what I would say, just to capture the idea, whether the losers in the conflict have been displaced, meaning are no longer physically in the location where the conflict occurred, or whether the losers remain in place, remain physically located in the nation. The more interesting and more, well, I don't know more interesting, but the more pervasive situations are ones where the losers remain in place, and that is also a description of the partial transition in Taiwan. But I want to say something first about the cases where the losers are actually displaced. And the two examples are separated by a very long historical gap. There may be others in between, but these are the ones that I'm using as examples. So in the United States, after the American Revolution, British loyalists essentially fled the country. They just did not stay in the U.S. They went to Canada or back to Great Britain. So that's the early example. The The late example is in Sri Lanka, in which the conflict was resolved by the extermination of the fighting force that had been opposing the government. I mean, literally extermination. They were just all killed. So they're no longer present. I mean, it's just not. Now, in those situations where the losers are no longer present, there are two characteristics. One is that in some sense, a domestic resolution of the issues or domestic remedies are unnecessary because there's nobody domestically left to be characterized as the victim. I mean, historically, the Tamils, they're dead. They were victims, but they're no longer there to claim victim status. Domestic remedies are not only unnecessary but unavailable because the winning party has so dominated this conflict that they see no reason to do anything about it. That doesn't mean that that there are no remedies for the losers or victims in this context at all, but that they're not going to be domestic remedies. So they will be international remedies. In the U.S. situation, the Treaty of Peace between the U.S. and Great Britain had provisions dealing with the compensation of the loyalists whose property had been confiscated within the then United States. In Sri Lanka, and this is going to have some bearing on some other things I'll say in a few minutes, I believe I saw a story, but if I didn't, it will happen, that there is some mobilization of international human rights institutions against the perpetrators of the extermination of the Tamils. Do you, Bill, know if there's been some action by the criminal court or something?
I believe
Yeah. So it will be it will be an external international inquiry into the problem. Okay, so now I want to turn now to the situation where there are significant numbers of I call them losers, the formerly dominant group in place. And here, as Professor Hwang's presentation indicated, the enduring problem of transitional justice is to accommodate interests in domestic peace, as he put it, and I think that's the sort of standard way of putting it, and the interests in justice, not transitional justice, just ordinary, everyday justice. Now, these are going to be affected by the size and power of the people who formerly held power, size in numbers and power in other kinds of institutions. And it's worth noting here, for example, that the contours of the South African resolution were importantly defined by the fact that the white elites remained extremely powerful in the economy and were in a position to threaten serious disruption of the economy if they were not accommodated, essentially by capital flight, in a situation in which the now governing party desperately needed economic investment to improve economic conditions for the black African population. Okay, so now the reason that there's a problem is that there are on both sides, there are resentments and concerns about retaliation that are difficult to accommodate. the running into the torturer on the street is a more or less standard story around the world. In Chile, there's I want to say the Kreutzer Sonata, but that's not the name of it. But there's a story about a woman who, by chance, confronts the person who tortured her, or maybe tortured her. I mean, there's uncertain. Okay. So this happens all over the world in transitional situations. So the former victims, the previous victims, resent the persistence in power or the undisturbed lives of the perpetrators. But they're unable to do much about it because of the position that the losers, perpetrators still have in the society. And Professor Hwang noted a number of methods of addressing these problems with the Spanish approach, which I want to say a bit about in the conclusion. At one, which is just let the past lie and move on, to the pure justice situation, which is what I would describe as the lustration kinds of examples, and with the South African one in the middle. I want to note a couple of things about some other, I call them institutional mechanisms to deal with these problems of domestic peace and justice. The first, they're both mechanisms that involve the invocation of something outside the domestic legal system. Now that has the advantage of removing the issue from domestic politics. It has the disadvantage of bringing people into the process who, in some sense, don't have to live with the consequences. And so who may make things worse rather than better. Now, the first kind of invocation of these external things are the invocation of external standards, international human rights standards. The most dramatic examples of these come up in the lustration problems in Eastern Europe. Where, and again, this has some tie to some of the things that Professor Hwang said. In many cases, the abuses that took place in Central and Eastern Europe were, as a matter of positive law, lawful when done. They were authorized by the standards in place. They were constitutional, consistent with the then in place constitution. So they were lawful when done. And imposing sanctions on people who engaged in activities that were lawful when done is normatively problematic. You can call it an ex post facto problem in a criminal context, but it's just it's nervous. It makes people nervous, particularly when you're dealing with the actual perpetrators, who tend to be relatively low-level, essentially bureaucrats, just employees who were doing their jobs. And while you might hope that people would be heroes in resisting orders to do this sort of thing, you can't really expect it to happen. So it's normatively bothersome. The solution that was arrived at in some of the Eastern European countries was quite ingenious, although not ingenious and problematic in its own way. What they said was, we will not apply domestic criminal standards, today's domestic criminal standards, to the activities of the perpetrators, but many of those activities were unlawful as a matter of international human rights law when they were done. So they were domestically lawful when they were done, and we're not going to apply domestic standards to them, but they were internationally unlawful when done, and so we can apply, we won't be applying retroactive standards to them. It's a very ingenious solution. The difficulty with it is the claim that the activities were violations of international human rights law when they were done. International human rights law in the 1950s was much more amorphous than was claimed in the 1990s when these cases were brought. So that's one solution. Apply external standards. The other solution is to invoke international institutions, to bring international institutions into play. And that's been the most common or the most discussed example is the intervention of the Inter-American Court on Human Rights with respect to the Latin American transitions. The Latin American transitions were negotiated domestically. The former dictators left. They left without violence, but they left with the assurance that they would have amnesty. It was part of the deal. Okay, now, as time goes on, this is a relevant point that I'll come back to in a moment. As time goes on, the deal seems, it doesn't seem to the victims worth honoring. And they pursue remedies domestically, but also in the Inter-American Court, saying that the failure to provide a remedy, the failure to provide a current remedy, or another way of putting it is the amnesty, is a violation of their international human rights under the Inter-American Convention. And the Inter-American Court has been quite receptive to those claims, to the point where amnesties are, I think it's fair to say, amnesties in these transition situations are, as a matter of inter-American law, unlawful. You just can't do it now. Did it then, but you can't do it now. This turns out, just I want to note, on the policy level, it's fine for Latin America because all the transitions have occurred, and then you'll see what happens with Hugo Chavez, and but he's just going to die probably, and then it'll be over. But it's not clear that he counts in the same way as the colonels in Argentina count as an authoritarian government. But it would be, I mean, many people think it would be really bad if the Inter-American standards became international human rights standards, because it's clear that the rule no amnesty just is an obstacle to getting rid of the dictators. Some of them, not many, but some of them are willing to leave if they're assured that they're not going to be prosecuted. In Africa, there's this complication of the International Criminal Court and the arrest warrant for Sudan. I think it's Sudan. It makes things much more difficult. So, anyway, one of the things that happened in Latin America is that one of these cases involves the Argentinian amnesty. And after the transition in Argentina, the Constitution of Argentina was amended to say that the law of the Inter-American Convention is domestic Argentine law, so it's enforceable domestically directly. Well, that now turns out to raise an interesting question, which is this amnesty, which is unlawful according to the Inter-American Court of Human Rights, is that amnesty now unlawful as a matter of local, domestic Argentinian law? For I think perfectly understandable reasons, the Argentinian Supreme Court is not happy with saying the amnesty is domestically unlawful. It would place them under a great deal of political strain. And they haven't resolved the theoretical problem. I could talk about the theoretical issue in questions. The one final point I want to note here is actually it's related to the Spanish example and the Argentinian example, and at some level, maybe the Taiwanese example. And that's the difference between the short-term problems of transitional justice and the long-term resolution of those problems. In the short term, these problems, where the losers remain in place, these problems are very difficult to resolve, and basically you will have something like the lack of resolution that Professor Hwang described for Taiwan in the short run, just because it's too hard politically, and there are other things that the now dominant group wants to do. It's just not worth the fight. Over the long term, two things happen. One is that it becomes easier to do, because just in the crudest sense, the perpetrators start dying. And they get, and if they're not dead, they're very old. This is Pinochet. I mean, he escaped justice because he died. And so it becomes easier to deal with. There are fewer people around who could be treated as perpetrators. At the same time, at some level, and this I think is the Spanish, the reason for the Spanish resolution, it also seems pointless. You have these, they're all men, you have these old men who, of course, you now think were criminals, but, it's just, they're competing, call them humanitarian considerations about taking a 90-year-old man and putting him in prison for the last 2 years of his life. It's sort of completely symbolic, and the symbolism comes at some cost of. So on the one hand, as time goes on, it gets easier. On the other hand, you begin to think, well, let's figure out some other way of dealing with it. I do want to say just one last thing, which is tied to the last slide of the memorial tribute. One of the things that can be done are these sort of culturally resonant symbolic actions. And one of the things that's worth thinking about, I think, is we can do this in two ways. In what cultures would this kind of symbolic action resonate importantly? And in what kind of cultures would it seem sort of a cheap and easy way of getting out of the issue? Here's living in Washington. There are lots of monuments in Washington, and I find it it's interesting that, first of all, the Vietnam War Memorial really does have powerful cultural resonance. It's really very powerful. There is, as of like 5 or 6 years ago, a memorial to the victims of the Japanese internment, which is okay, but it's not. It doesn't resonate. It's not, because these kinds of things are not part of the U.S. culture. I wonder about the whether cultural recognition in Spain of the victims of the Franco regime of this sort would matter within the culture. I just don't know. I found it interesting. I found it interesting that in Professor Hwang's presentation, the creation of memorials was something that he picked out as significant. It's not clear to me that a U.S. scholar talking about U.S. things would have picked out memorials in the same kind of way. Maybe, but it suggests that there's a cultural dimension to this that's worth thinking about. Okay, that's all I have to say.
Professor Hwang, do you want to respond or do you want to just open up?
Just open the floor.
So we are now open for questions. So. And please briefly say your name and affiliation.
All right, my name is Kevin Chan. I'm a visiting scholar at the Yanjing Institute here at Harvard, and I come from Taiwan, working at the Academia Sinica in Taipei. And I have a remark on Professor Hwang's talk and a response to Tushnet's comment. And I think an important element of the White Terror is the Secret Service Agency. And I just watched a film, a German film called The Lives of Others. So anybody actually was watched over by the Secret Service, and even those people in power. And the secret files you referred to in your talk were many regards trials. And so I don't think that we have paid attention to the files the files of Secret Services that actually were opened in East Germany in the 90s. And that actually had an appalling effect. You will realize that every dimension, everything you did, even your sex life in your own house actually was eavesdropped or was watched. And then that would probably have better effect, or that would probably opening those files probably would work better for redemption or for any measures for transitional justice. And then the comment on Professor Tushnet's remark, and that is that transitional justice actually becomes more difficult in Taiwan as time goes on, because for the youngsters, first of all, the second generation of the perpetrators actually were politically and culturally affluent, and they control 70 or 80% of the media. So the public opinion was very often on their side, and any idea any idea of transitional justice for them was just a revenge, an immoral revenge, because they thought they were not responsible anymore, and they paid lip service to what went wrong in the past, but again, that becomes nobody's fault because they were not in power back then, or they were still young, they were still lower in ranks. And for young people, they hardly think that's relevant anymore. And so to do something politically or judicially effective for transitional justice, that becomes pointless to them or unnecessary.
Let me just say something about that last point, which I think is one of the things that I think, I think speculating, but it seems right to me, that might happen is that as time goes on, call it the circle of eligible perpetrators narrows, not just because of age, but because it does seem pointless to go after the relatively low-level people, the people who say we were just doing our jobs, the people who are captured in the newspaper stories that it's just revenge. So it narrows to the most high-level people, the Pinochets or the Francos, or I think there's Demjanjuk, who just died. The really bad people get singled out. There are many fewer of them, which actually makes it easier to deal with them. And because they're really high, they probably don't have a great deal of sort of normative force behind them. But because they're really high, they're really old by this time. They're not the youngsters who were the soldiers who were, going into houses and breaking down the doors and that sort of stuff. And so you have these competing kinds of considerations. I didn't say anything about the South African Truth and Reconciliation process, but it's probably worth mentioning there that it happened very soon after the transition, and it's generally regarded as not having been terribly successful. The amnesty part of it was quite strongly resented by the African community. So, one thought that has just occurred to me is that maybe with respect to these late stage issues, a truth and reconciliation process might work. The Truth Commission, with respect to the White Terror, might work because it's now receded far enough in the past to be a possibility.
Regarding the opening up of the secret file, well, I totally agree with your comment. I guess the classification of the secret file should not be limited to those cold files, the judicial cases only. But the problem is, so far as I know, the government, even the DPP government, had much difficulty in just knowing how much file and where those files were. Yeah, even when the DPP government was in power, for example, the former president and his government asked the Ministry of the Defense to provide information to the government, and he was resisting for a couple of years, and only in the end they presented just a very limited scope of the document and turned it to the government. So, well, I guess there's part of the problem, as quoted by Professor Tushnet, is the incomplete transition in Taiwan so far. Yeah, not only I mean by that I don't not only the parliament. I mean, if you look at the military, and if you look at even the courts, they are still dominated by those guys. Yeah, they're still dominated by those guys. So it's rather difficult, even within the not only the executive branches and also the judicial branches, to demand so-called justice, or well, not to mention just to demand truth from them.
So if my question is inappropriate, please correct me. Thank you, Professor Hwang. Great to have you back. I think one thing that complicates some of these issues in Taiwan that may be different from some other societies is the perception, maybe inaccurate, the perception that some of the efforts at seeking transitional justice have to do with underscoring Taiwan identity in the ongoing tensions with the mainland. So I wonder how you, if you're a proponent, as I know you are, of justice in the best sense, how you do away with that. It being understood as nothing more than, or primarily about solidifying Taiwan identity, and less to do actually with abstract justice or restoration.
Yeah, I agree with you. As I pointed out in the last second, the parliamentarity. Yeah, a lot of people regarding the issue of transitional justice as a issue of power struggle between the DPP and between the KMT, and also they regard it, as you say, as a pretext of forming a Taiwanese identity. But in fact, if we look at the statistics, as I once said during my transition, particularly during the White Terror period, during those 4 decades, in fact, the so-called mainlander, the mainlander victim accounted for almost 40% during that period. So I think it should be a good starting basis to build consensus on this issue. Yeah, we are not. The reason why we are seeking justice, we are seeking transitional justice, is, well, I would say it's nothing to do with the so-called Taiwanese identity. Yeah, even, well, you can see almost a half of the victims during those 4 decades are so-called mainlander. Yeah, so what KMT did is not only to suppress the Taiwanese, but also to suppress whatever who oppose him. So for that part, I guess we still have a long way to go. And then I think, Professor Alpha, you are right, because even when DPP was in power, in the first beginning, in the first 4-year terms of the Chen Shui-bian president, he rarely mentioned transitional justice, only after very, very late. And what was worse is he began to mention this issue during the campaign, electoral campaign. So, well, that reinforced also, as you said, the public impression that, well, this is only an issue for power struggle. You are not demanding so-called true justice or the truth at all. Yeah, so, well, I guess to a certain degree, it was very, very unfortunate for the transitional justice to be pursued in Taiwan. But for the future, I feel we still need it, and we should build on probably a newer, more complete, a new basis based on the more complete so-called facts, and to let not only the Taiwanese but also the so-called mainlander were all suffer. They were all suffer. They were both victims during this period, and particularly for the purpose of the future so-called democratic education for the future generations. Yeah, I'm sorry.
You're sort of picking on my point. My name is Diane Williams. I'm a computer scientist and entrepreneur. I'm an alumna of MIT, Sloan, and Harvard Graduate School of Education here. It's very interesting that I just got information from Google that it's a work in progress, but they have the complete archives of Nelson Mandela, all his works, all his writings while he's in prison, basically his life, and anyone in the world, obviously, who has a computer or a phone can access this information. And while I'm very intimately familiar with the Truth and Reconciliation Act, I was not, until I walked in here, I didn't know anything about 228 or anything, and I find it very interesting. And one of the things that really distressed me is not only when you say people who are going to die, meaning physically they'll just pass on, but the destruction of history and a part of the suppression. And I think maybe one should take advantage of the fact that you can put these documents, whether you have oral histories online, or so that those of us who are outside who don't know how many histories are similar, or how much you have with whether you have the Nazis or South Africa or what happened in many Latin American countries. Possibly people can give you suggestions or help to help you deal with the situation. You understand what I'm saying? In terms of truly digitizing these stories and not letting them pass on. People have a tendency to suffer silently within their families or within their communities, and the outside world may not know the extent of the damage that has been done to society.
Yeah, I agree with you, and I'm sure there are quite a number of people, particularly from the NGO part of the society, they have been doing things, as you say, to preserve the document, and by producing not only the oral history, but also by digitalizing all the film and things like that. But the problem is the Taiwanese government is not very enthusiastic about that. Yeah, so the problem is how can we convince our government this is good for not only for us now, it's good for the future, it's for or even for the world. Yeah, I guess the lesson we want to remember, and also we want to teach to our future generation is let's say never again. Yeah, as many people say never again. Yeah. The reason we are demanding this is we don't want things like this to happen in the future. Okay. Yeah, but there will require a lot of work to be done. Yeah, as far as at least in Taiwan's case, we are still far from satisfied. Not at all. Thank you.
Hi, my name is Wen Tao. I'm from the business school, and so I wonder, because you're like comparing, the transitional justice in Taiwan and the United States, and one thing that in the United States that people have been doing is, to treat the, offsprings of those who have been mistreated in the past, like nicely. So, for example, the Native Americans and the African Americans have been mistreated in the American history, and now the government is doing affirmative action, to provide them better opportunities to go to universities and to, get better jobs. So I wonder if anything like that has been done in Taiwan. What are people thinking about?
As I show in this slide, yeah, you mentioned the affirmative action at the bottom of the middle column, and then so far in Taiwan, practically we don't have any whatsoever the affirmative action for those beaten or their family. Yeah, the only thing probably could be called affirmative is to restore, to reinstitute their position before that. Yeah, for example, there were several university professors who lost their job because of the whatever trial, and then after 10 years ago when we began to pursue this issue, and several of them were reinstituted back to their position as a university professor, but because they are kind of old, so it's very symbolic, yeah, to put them back to in the university, but only after 1 or 2 years, and then they retire, so they can retire as a professor. But I don't think it's kind of, as you say, it's like a comprehensive affirmative action at all.
I'm actually not sure about if this remembering is exactly what is happening, because to me it seems that there's also to some extent denial rather than this remembering. So in my recent trip back to Taiwan, I had a friend who was visiting Taiwan, and I showed him to do a memorial. So it's not just the memorial, it's actually a museum, and there's a museum that talked about what happened during that time, and naming Chiang Kai-shek as one of the person who know what had happened, and even if not making direct command, he actually was backing that. So there was that. But before showing him this memorial, I took him to Chiang Kai-shek Memorial just to contrast, And Chiang Kai-shek Memorial, I was really surprised when I found this souvenir shop, which are selling Chiang Kai-shek, cute version of Chiang Kai-shek souvenirs, like really making him cute, without clear political messages, right? So there are people looking at the souvenir gift shops, and there are people still venerating that regime and that legacy. So, that kind of this remembering itself is not a transitional justice model. It is injustice.
So I put it in this graph, I call it transitional injustice, and then at the bottom, I set it here, continuing to spread Chiang Kai-shek's statues and all kinds of authoritarian symbols. A couple of years ago, about almost 10 years ago, I once had met a friend from Canada. Yeah, he once told me his impression every time when he come to Taiwan, and then because the international airport of Taiwan now is called Taoyuan International Airport, but in the past it was still called Chiang Kai-shek Memorial Airport. So simply he told me it's kind of weird for him. He said, well, it's very much like when you go to Germany, and then before you landing at the Frankfurt airport, and what you hear from the cabin crew is, passengers, we are going to land at Hitler's International Airport. Yeah, but for him, well, probably that's his impression, that's his perception. But I agree with him. For many Taiwanese people, Chiang Kai-shek is still, a symbol of positive, not always negative legacy. So I guess there's still a big problem for Taiwan. Yeah. Well, so well, in this sense, I would say Taiwan case is also very more sad or postmodern. Yeah, you have all kinds of different opinion about the history, different perspective, different interpretation of Chiang Kai-shek. Yeah, someone still regarding as a kind of national hero, even in our school textbook right now. Yeah, he still described as kind of national hero. Yeah, a sort of national hero. Yeah, even in the textbook. Yeah. So, and then there will be only one sentence, say Chiang Kai-shek could be responsible for those blah, 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 things. But for the most part of it, well, his image, and you can see actually you can find Chiang Kai-shek everywhere in Taiwan, particularly in almost every school, from the elementary school to the university school, each school in Taiwan used to have at least one Chiang Kai-shek statue, even right now, even until now. Yeah, not only ago, last month, a group of university students in Taipei, they kind of decorated the statue of Chiang Kai-shek with some sort of red pen, some sort of, yeah. And then the university threatened to charge those students for destroying public property or things like that. Yeah, so you can see things like that still happening in Taiwan. So it's quite complicated, and I don't think, well, that's why we got stuck here, and then probably, I'm not sure if we can go any further in any realistic sense in the short term. But I will agree with Professor Tushnet. Over the long term, yeah, we should still, and then probably we should think in the longer term and better rather than in the short term. That would be more feasible.
Maybe one last question, please. Do you raise your hand or? Okay, please.
It's interesting to see how there is a difference in what happens in different countries as time goes on. And your last question was, I don't see really how this can change now because of the things that are still statutes everywhere and still people still like it. And I must think about what happened in Spain and about what has been said about Spain already before. It's true that the deal when the Franco regime got down was, let's just forget about the past and let's not do anything with it because it's the only way that we can get rid of the dictatorship. But as time went on, there are reasons to assume that the need to clarify things diminishes because people die and not too many people were actually involved with it. But today you can see that the younger generation does not really feel bound by that original bargain of the 1970s. So it's more or less a generation conflict now there, because of the generation of 20-somethings do not really feel, why should we forget about our past because of a deal our parents struck with a dictatorship. So now there are a lot of questions coming by people who want to know about their family, about their past, and about what happened. And it's really a conflict because a lot of the amnesty rules are entrenched in the law, and now people are challenging that as to why should we still obey these laws that people have made before and that we have nothing to do with. So perhaps, I don't know a lot about details about Taiwan, but perhaps the continuum of time can actually move even in a different direction. A new generation growing up and wondering what happened actually then, and what are the things that our parents don't talk about, or what do we want to forget. So perhaps it could go either way, but that's something I don't know.
Thank you. I hope be as hopeful for the case of Spain. Yeah, regarding the case of Taiwan. But well, certainly that's the direction I'm looking forward to seeing it in Taiwan in the future. Yeah, thanks.
Okay.